morning, students. A very good morning to you. We have today the next set of topic quasi contracts. What do you mean by quasi contract? As a term implies, quasi, it is not actually a type of a contract at all. It is a kind of a contract which is levied based on the principles of social and justice, sociality and justice. So we say in Tamil, Manasakshi Geta, right? That is what we say. So whenever we see the outside world, we feel that this is wrong. So this has to be corrected, or we feel that we should not take undue advantage or undue position over other persons. So we should act in a judicial manner. We should act in a courteous manner. We should know. We as the citizens know what is right, what is wrong. So based on the principles of the human tendency, based on the principles of human behavior, based on the principles of the social aspects of the human beings, right? So we classify the contracts as a quasi contracts. It is purely based on the individual behavior in a particular circumstances, how we need to act righteously. How we need to act righteously means how we need to behave in a courteous manner, and so that we should also try to earn a good name in the midst of the society people. So these are the principles based on which the contract has been devised, and it is purely based on the principles of sociality and justice. So these contracts are quasi contracts in nature. Under Indian law and English law, we classify these contracts. Under Indian law, it is purely said as an obligation which is created by the law. So what is the law saying? That you are, as an Indian citizen, you are obliged to follow certain principles and ethics, and you need to adhere to it. So it is a self-imposed obligation on you by the law. So it is an indirect thing. Law doesn't say that you have to do this, but it is an obligation indirectly imposed by the law on the person. That is what we call, in the Indian parlance, we call it quasi-contract as that. Whereas in English law, they already have framed it, and they are indirectly termed as, they have alternative names in place, which is called implied contracts or constructive contract. They are implied contracts. Means implied, what does it mean implied? Implied means it is inferred from the conduct and circumstances, behavior, situations, and the surrounding things which are in the environment, right? It is purely based on the conduct and behavior of the person, the evidence, the facts, situations, circumstances. So these are all called the implied contracts. They are also known as constructive contracts. Whereas in Indian law, we are called as quasi contract. The same thing under English law, it is termed as implied contract or constructive contracts. So as per provisions of section 69 of the Indian Contract Act, slowly moving to section 71, 72, 73 and all, we are actually dividing the contracts into various types and various categories, or we classify as classifications, right? So types of quasi contracts are there are basically into 5 basic categories of quasi contracts. First is necessities supplied to incompetent persons. When I say incompetent persons, what do you mean by incompetent persons? So before we that, first we will discuss about all the 5 points, and then we will slowly discuss into one by one. One is necessity supplied to incompetent persons. Second is payment by interested person. Third is benefit of non-gratuitous act. Fourth is finder of lost goods category. Fifth is money paid or benefit given under coercion. We will slowly go into one-on-one category. I have given examples under each category. We will also try to illustrate with the help of that example in a brief explanation. Okay. First is necessity supplied to incompetent persons. What do you mean by necessity? Necessity supplied to incompetent persons. Supplies means providing. What is necessity? Generally, a human being needs 3 basic things. What are the 3 basic things? Food, clothing, shelter. Correct? Food, clothing, and shelter. You have food to eat, clothing, good amount of clothes to wear, and a shelter, a place to take rest and sleep. Right? Food, clothing, and shelter. So this is the bare minimum necessity that is needed by any individual. So even for an incompetent person, as is said section 4, we already discussed about certain categories of people who are incompetent. Who are they? Minor, lunatics, idiots, drunken, intoxicated persons, right? So we discussed in chapter number 4, persons competent to contract, right? So those category of people. So wherever a person who is providing necessity, maybe a rich person or a businessman or even an ordinary person who is providing such necessities to a minor or any incompetent person. It need not necessarily be a minor. It can be even any other category of incompetent person. But if you try to provide a necessity to an incompetent person, that is necessity as we mean cost of education, good amount of drinking water facilities, good amount of health provisions, education or kind of a cost of education or any training kind of things, programs, and we also have food, clothing and shelter. All these are all necessities which a man bare needs as a bare minimum, right? This is needed by the individual. So whenever we are supplying these necessities, any rich person or any category of person who is more providing these necessities, is incurring these expenses to a person who is a minor, that is, or any other incompetent person but is providing necessities, what happens is last stage that whenever cost of such necessities are provided to the minor and later the person providing the necessities wants to get back the cost, he has incurred the expenses, right? So he wants to get back the expenses from the minor or the incompetent person. He wants to file a suit against the minor. It is not possible. What the law says is that you cannot file a suit against the minor or incompetent person personally. Please understand, only when you have a property, only when you have any other estate, only when you have any other asset of the minor, you can file a case against the minor or the asset or the property of the minor, reimburse the amount from the minor or the incompetent person. You cannot file a case against the minor personally. Please understand, you can only file a case against the minor asset, minor property, minor estate, or any other incompetent person asset, property or estate. Okay, so now best example is cost of housing, education, etc. provided to the minor by a rich businessman. Okay, where a rich businessman tries to find a minor and is providing cost of education and is also bearing house, other facilities is providing to the minor just for the minor to live and get educated and to live happily. But later point of time, he wants to sue the minor for the cost so incurred, or he wants to get back the cost incurred. So he cannot file a suit against a minor personally, as I said. Only when the minor has any other property, benefits or any asset or this category, he can file a suit against the minor and get the amount recovered or reimbursed. This is the first point, necessity supplied to the minor. So this is first category of the quasi contract. Clear? Moving to the second point is payment by interested person. For example, under the law, if A is going to get a money of rupees 1 lakh from B, B is the money lender, A is the borrower. Okay, A is the borrower and B is the money lender. So B is going to give 1 lakh rupees to A, but is going to say you need to pay within so and so period. But at the current situation, A is not able to pay. What happens is C, who is a friend of A, goes and repays the money of 1 lakh to B. Now C is interested in A, right? That is why he is a friend of A, so he is interested in A. So he is bearing the amount of 1 lakh and he is paying the amount of 1 lakh to B, to A, who is the money lender. Okay, so on behalf of B, C is now paying the entire amount of 1 lakh and settling the debt of B and paying the same to A, who is the money lender. So now money lender A gets the entire amount from C. Okay, so now the debt is discharged. Therefore, on behalf of A, C, the friend of B, on behalf of B, C, the friend of B, is reimbursing the entire amount of 1 lakh to A, who is the money lender. Therefore, any payment made by the interested person, then such contract is also a quasi contract. For example, A pays 1 lakh rupees to C, but B has paid to C. Okay. Same example. Going to the third category is benefit of non-gratuitous act. What is non-gratuitous act? Anything which a person is not intending to do so, but it has gone in such a manner that it is gratuitous, similar to a kind of a mistake done. But what happens is, as a result of that mistake, some third party is taking benefit out of the transaction. For example, A and B enter into a category or a contract for purchase of some household products. A is the seller, B is the buyer. Okay, A and B enter into a contract. Now what happens is, B has ordered certain household appliances and articles with A. He has made the payment to A. But what happens is, A has he has not assumed the case, he has not made the payment. Okay, so for example, A and B enter into a contract. B has now ordered certain household utensils and appliances with A. What happens is, A now delivered the products to C instead of B, because B has ordered, but by mistake, A delivered to C's house, which is next to B's house. He has delivered the products to C's house instead of B's house. Whereas B is the person who has ordered for utensils, but A by mistake delivered the products to C's house. But now what happens is C has treated the goods as his own goods. He has taken advantage of this transaction. He knows that it has to be given to B, but by mistake it has been delivered to C. Now C is treating the goods as his own goods, and he has started using the goods. Now C is liable to pay A because he has now started using the goods. Or he has to at least call B and return the goods to B, but he has not done so. In that case, any person who is taking advantage of the wrong transaction and taking any benefit out of the transaction is bound to reimburse to the other. He is bound to take the debt. So that is the quasi-imposed obligation based on the principles of equity and justice. Fourth is finder of lost products and goods. Here, where a person who finds a lost purse in the midst of a road, there is a purse which is lost in the midst of the road. The purse belongs to A. But what happens is on the way, some other bypasser finds the purse belonging to A on the middle of the road. But the bypasser knows the purse belongs to A. But what happens is he is trying to find the owner A and he is trying to give the purse to A. It is the logical basis of doing it. He should not treat the purse as his own and take away the money and run away. It is not possible. So he has to find out the true owner who is A, where he is residing, and he has to give the purse to A. It is the logic because he finds the purse belonging to A in the middle of the road, and the naturally imposed obligation on him is to find the true owner, return back the purse to the true owner. This is the quasi-imposed obligation. So this is our fourth last category is money paid or benefit given under coercion. Where any person is getting any benefit by imposing physical threat or violence on the other person and derives a benefit out of that other person, he is bound to return back the benefit or money so derived to the other person on whom the coercion or physical force or violence is employed. Please understand. For example, A is going to throw a gun shoot against B, stating that he is forcing B to deliver his property by taking a gun and showing it against B and then asking him to sell his property immediately for rupees 20 lakhs. So A is bound to pay 20 lakhs, he is ready to pay. But the problem is now he is forcing B to sell his property, whereas B is not willing to do so. Okay, by using coercion or use of fear of death by showing gun against him or use of physical force or threat etc. violence, A is trying to get the property of B. So B is now bound to give, otherwise he will be killed. Therefore he is under coercion, under fear of getting died, he is transferring his property to A. What happens is this transaction is purely a transaction which is through employment of force and violence and coercion. Therefore, A has received the property from B by employment of force or by employment or using of physical threat etc. Therefore, under this transaction, it is a quasi-contractual obligation. Therefore, A is bound to return back the property whatever is received from B because it is induced by coercion. He has to return back the property to B. So this is the money which is received or benefit given under coercion has to be reimbursed to the other person. This is also known as doctrine of restitution. So these are all the 5 different categories of quasi-contracts, which are quasi-contractual obligations rather imposed by the law on the individual who is supposed to follow based on the principles of equity and justice. Okay. With this we are closing this quasi-contract topic. Okay, students, moving to the next topic, we have contingent contract. Contingent contract is something which is contingent. What do you say contingent? A popular, very joke in Tamil, it happens like ennatha kannaya, right? You say that ennatha panni, ennatha panni. So it's the same concept, right? When you say contingent contract, nadakkum ana nadakadu. So this is a kind of examples, the best example for contingent contract. Contingent contract is also known as conditional contract. You say conditional contract because it imposes certain conditions based on the fulfillment of which the contract may not be enforced. There is an event which may or may not happen, but the event is a driving factor which may or may not happen. Based on that, the contract is contingent. Contingent means depend upon. When you say depend upon a particular event, but the event may or may not happen. So a contract which is contingent upon an event happening, not happening, are those kind of categories which will follow as rules. Okay. The definition as per the provisions of the Indian Contract Act say contingent contract is contract to do. Whenever we are trying to do a contract, we are trying to do a particular thing or an act. A contract to do, to perform or not to perform. either perform or not to perform something, some act or any other event, right? If some event collateral to such contract arises or does not happen, which means that whenever you are trying to do a contract, you are trying to do a particular activity or a particular event, but that event is dependent upon another event, but the other event may or may not happen, but the happening non-happening drives this event. The happening non-happening of that event will drive this event. Okay, that is called contingent contract or conditional contract. For example, A promises to pay 1 lakh rupees to B if B's house is burnt. B, you are trying to burn B's house, and if you do so, he will pay 1 lakh rupees to B if B's house is burnt. So this may not be possible. So this is the best example is contingent contract. It's the best example of contingent contract. When you come to rules, section 32 to 36 of the Indian Contract Act clearly specifies certain criteria where you have to classify, or these rules will be applicable for contingent contract. One is enforcement of the contract, where the contract will become valid and binding. We say enforcement means valid and binding of the contingent contract. On the event happening, when the event is happening, the contract can be enforced. When it is not happening, it will not be enforced. Here, the contingent contract, here, the contract is dependent upon the event happening. This event has to happen. Only when it happens, the contract can be enforced. If it is not happening, the contract cannot be enforced. So, enforcement of contract of the event happening. A agrees to pay B if B marries C, but C dies. This contract cannot be enforced because the contract is between A and B. What A is saying, he agrees to pay B rupees 1 lakh only when B is going to marry C. But C dies before the marriage. This is not possible because now the contract between A and B to pay 1 lakh is not possible because B is unable to marry C because C dies. Therefore, this contract cannot be enforced. Only when the event happens, the contract can be enforced. The event doesn't happen, the contract cannot be enforced because the focus is on the event happening. So, positive attitude first is event happening. So, the focus is on events happening. So, contract will be enforced only when the event happens. Contract will not be enforced if the event doesn't happen. Okay. Second part is negative. Contract can be enforced only on the event not happening. When you say event not happening, best example is when A agrees to pay B rupees 1 lakh. If he sees a ship, it doesn't come to the harbor within 1 year. There is a ship which has gone out of the seas, but A is promising to pay B rupees 1 lakh. That if the ship does not return to the harbor within 1 year, 1 lakh, within 1 year, you will get a 1 lakh rupees payment which I promised to give you. But unfortunately or fortunately for B's promise, A's promise, what happens is the ship is sunk into the sea. It doesn't return 1 year, within 1 year. Therefore, performance of the condition is fulfilled because A is already said to be that only when the ship is not returning to the harbor, I will pay you 1 lakh. Obviously, because the ship is now sunk into the sea, it will never return to the harbor. So, the ship is already destroyed. It has gone into the ocean. Therefore, ship will never return to the harbor. As promised by A, he is bound to pay B because the condition is fulfilled and the ship doesn't return to the harbor. So, event is not happening. Therefore, the contract can be enforced. Third category is future conduct of a person decides the enforcement of the contract. How a person will behave at an unspecified period of time, his behavior, his conduct will drive the enforcement of the contract in the future. Based on the future term and his conduct of the living person, that will decide the enforcement of the contract. Best example is A agrees to pay B rupees 1 lakh if B marries C. B will get a 1 lakh rupees from A only when B is going to marry C. Whereas C, the lady, already married another person D. Now, the marriage between B and C is totally not possible because C is now married a D. Therefore, now the contract is not enforceable because how the person will behave at an unspecified period of time will not know. It may or may not be positive to our side, it may be even negative to our side. So, we will not be able to judge how the person will behave or conduct at a future point of time. We thought that B will marry C or C will instead marry B, but what happens is she had married a D. Therefore, we don't know how she will behave. So, therefore, future conduct of a living person will decide the enforcement of the contract. The fourth category is enforcement of the happening of the specified event within fixed time. Parties usually enter into the contract, they will fix a particular time, 3 months, 4 months, or even 1 month or 2 months. Within that time, that event has to happen. Please understand, specified event. Parties will agree upon a particular event. They will also agree upon a fixed time. Please understand, there are two important points: specified event and fixed time. The event is to be specified. This event has to happen. So both of them agree on the specified event. Second is, both of them agree on the time, 1 month, 2 months, 3 months, etc. So both of them are very clear with respect to the specific event and the time. Within the time and within the specified event, the event has to happen. If that event within a fixed time is not happening, the contract cannot be enforced. If the event is happening within fixed time, contract can be enforced. Right? There may be case of example, A is going to pay 50,000 to B within 1 hour if it rains. Within 1 hour if it rains. We don't know whether rain will come or not within 1 hour. But within 1 hour, rain comes, fine. Rain doesn't come, cannot be enforced. So we don't have as humans any influence on the rain. So it may or may not come. So we will not be able to judge how it will, whether it will come or not. Therefore, the specified event is raining, the time is 1 hour. So both of them are agreeing to the two basic elements. And if the event happening, it can be enforced. If the event doesn't rain, the contract cannot be enforced. So, clear? Next part of it is specified event not happening within specified time. Again, the parties agree on the specified time. The parties agree on the specific event as well. But please understand, the enforcement of the contract will be done. Contract will be binding only when the event is not happening. Here the focus is, it should not happen within the fixed time. The same case, A is promising to B 1 lakh. If the ship does not return within 1 year, they agree to a ship not returning to the harbour within 1 year, then A is going to pay B 1 lakh rupees. So obviously, if the ship doesn't come to the harbour within 1 year, the ship is not returning, therefore it is not happening within 1 year, that is fixed time. Therefore, contract can be enforced. Because the failure of the event not happening, in that case, contract can be enforced. The last part is impossible events. When you come to the fifth category, 1, 2, 3, 4, 5, 6, sixth category, right? Yeah, impossible event. Impossible event means the contract is depending upon an event which is totally impossible to perform. When you say a contract is impossible to perform, obviously the contract cannot be enforced. Law does not recognize what is impossible. Okay? Impossibilium mula obligato est. That is the Greek word which says that what is impossible cannot be enforced. So, impossibilium mula obligato est is a popular Greek or the Latin term that is actually given in the law, which states that law does not recognize what is impossible. Therefore, A agrees to pay B rupees 1 lakh if B is going to take A to the space station. Space station is in the galaxy, right? Near Saturn, Venus, Mars, Sun, Moon, etc. If B is going to take A to Saturn, Venus, etc., we also can go. It is not possible, right? So, an event which is not at all possible, it is totally cannot be enforced. Therefore, contract can be enforced on the happening of an impossible event. Is totally cannot be enforced because the event itself is totally impossible to perform. In that case, contract cannot be enforced. Therefore, these are the 6 categories. I will again repeat: enforcement of contract on the event happening. Enforcement of the contract focuses on event not happening. Then enforcement of the contract focuses on future conduct of a person, how the person will behave at unspecified period of time in the future will decide whether to enforce or not to enforce the contract. In enforcement of the contract, specified event happening within fixed time. The event is specified and the time is fixed, and both has to happen within fixed time. Specified event is fixed and then time is fixed, but the event should not happen within fixed time, then only contract is enforced. The last category is impossible event, where totally what is impossible law does not recognize, and therefore impossible event contracts cannot be recognized, cannot be enforced. So students will move to the next topic, performance of contract. When you say performance of contract, what do you mean by performance? Doing the respective obligations under the contract. There are two parties, as I said, in the contract. One is the promisor and the promisee. The second part is the promisee, or we also call it as an acceptor. A is going to deliver his car of 1 lakh rupees to B. So now A has to deliver his car first. it is his performance obligation because he has agreed to deliver his car to B. Based on the promise made by A, obviously A has to deliver the car to B. So it is his side performance obligation, which is promisor performance obligation. B, on the other side, is a promisee or the acceptor. He has to receive the car and pay the price to A, obviously. So it is his side performance obligation. B has to pay 1 lakh to A as per the terms agreed with the A. Price of 1 lakh is the consideration that B has to pay to A for the transfer of the car from A to B, and B has to pay 1 lakh rupees to A. So price being the sole consideration. So in this case, the performance of obligation on the part of both the parties is absolutely necessary. Then only the contract will be mutually, that is both sides regarded as mutually valid and binding on the parties. So performance of the contractual obligation, section 37 to 40 deals with certain important provisions which we need to understand as a contractual party. As students of this topic, you need to be very clear with these topics. Very important provisions are coming on from 36, 37, 38 and 40. 39 is not that important, so I have not covered. 37, 38 and 40. 37. Obligation of the parties to perform their respective promises unless performance is excused. Excuse means need not perform. So both the parties are bound to fulfill their obligations under the contract. Both the parties have to fulfill their obligations under the contract. Unless and otherwise they are excused or they are dispensed with or they are not allowed to perform as per the law. They are allowed to go free, they need not perform. Law has to specify or exceptional circumstances should excuse them from not performing, otherwise they are bound to perform. Best example is A is the promiser. He is promising to paint the picture for B. B is the customer, A is the painter. So B approaches A for painting a picture. A is now promising to pay B that I will paint the picture and give it to you on a certain day. They have agreed for Monday, Tuesday, etc. But what happens is, before the day arrived, A, the painter, dies before the day. Now the contract can be performed? No. Because painting is a skill which only A has. On behalf of A, the painter, nobody can perform the painting because painting is exclusive talent or brain inborn talent which is applicable to A alone because he is the painter. On behalf of A, somebody may paint, but it will not come as a paint, it will come to a different diagram. Right? So obviously painting is a kind of a skill which is applicable only to A. It is a personal skill applicable to A which cannot be replaced in A's absence. Therefore contract cannot be performed. So performance is excused. Clear? Contract for personal services, promisor is bound to perform. On behalf of him nobody can perform because personal services exclusive talent applicable to promisor alone. He cannot be replaced by another person. Section 38. Effect of refusal to accept performance. You need to perform, but your performance is not accepted. What are you supposed to do? For example, promisor is a person who offers to perform. He is willing and ready to perform. A is ready to deliver his car to B. Car is white, everything is clear, car is white, the car model is okay, car color is okay, price is okay, the day is okay, all the good things, time, auspicious time, everything is okay. But A is now ready to deliver the car from A to B. But what happens is B, the promisee or the acceptor is not willing to purchase the car suddenly because of bad mood, etc. He is saying that no, I am not ready to perform, I am not ready to buy the car. Earlier I agreed, but now I don't want to buy this car. Now what happens? A is not responsible for non-performance because A is now ready, even though he is ready to perform, but B is not ready to accept the promise. He is not ready to accept the promise of paying it and buying the car due to some other reason, etc. But in this case, promisor is not responsible for non-performance. You need to be very clear. Section 40. Person by whom promise is to be performed. Please understand. Who need to perform the promise? By whom the promise need to be enforced? As per Indian Contract Act, as I said earlier, this section little bit relates to this section. Promisor only is responsible for personal services or contracts. Wherever personal contract is involved, wherever personal skill is involved, dexterity we call, caliber we call, skill we call. we term it as skill, dexterity, talent, quality, the brilliancy, intelligence, etc. In various terms we call, right? So, the contract to perform a service or service to be rendered under the contract or any work is to be performed under the contract depend upon the skill, dexterity, talent, intelligence, knowledge of the individual or a promisor's knowledge that is attributable because of that exclusive talent that is belonging to the individual, that is a promisor. And his skill cannot be in any circumstances be replaced by any other person. Therefore, promisor alone is responsible for personal contracts or services. In the absence of his, in other contracts where contract is not depending upon personal skill of the promisor, maybe promisor in the absence of promisor or due to death of the promisor, representative of the promisor can perform. Otherwise, where a contractual work which is purely depend upon promisor alone, he is the only person he has to perform the contract. Best example is this example. Here A is the person who is a painter, he is bound to paint. For example, another contract, best example is A is a singing person who has exclusive talent of singing. He was agreed with the musical theatre owner, and the theatre owner said that you need to come and perform a musical song on a particular day. But what happens is on the way, A dies in an accident. He is the singer, he dies in an accident. Now the contract is not able to perform. The stadium is ready, the place is ready, the time is ready, the theatre owner is ready, musical theatre owner, everybody is available, but the person who is singing unfortunately dies in an accident, or he is alive but his throat is cut due and he is having some serious injury, the throat is not able to sing. What happens? Here, the singing talent is purely belonging to A's skill. Now, on behalf of A, nobody can sing because singing is attributable only to A. Therefore, in the absence of A or due to death of A, contract has to terminate, contract has to be concluded because A's singing skill cannot be replaced by another person. This is what I said. Personal services, personal contracts, personal skills, dexterity, knowledge is involved. That cases, promisor alone is responsible to perform because that is a unique talent to the promisor. In other cases, promisor or his representative, either of them can perform and enforce the contract. What happens as an effect to section 40? If the promisee accepts performance from the third party, there is already a contract between the third party and the promisor and a promisee. But what happens is, promisee instead has accepted the performance of the promise from the third party, from an outside party, external party. Later he cannot enforce the contract against the promisor. It will be very, very clear. Because for him, whatever is the work or whatever is the services, he has already derived it from the third party. Now he cannot go back and claim again from the promisor for the second time because he has got the service already done. We come to the next topic, students. Devolution of joint liability. Okay. This joint liability is popular. When you say joint liability, all of them are equally responsible. All of them are equally liable. All of them are equally responsible for the settlement of the joint debt which has been agreed to be paid by one set of people to the creditor. For example, if A, I will take an example here. If A, B, C, they borrow from D 1,50,000. So, in this case, we see D is the borrower, D is the money lender. Sorry, let's take D is the money lender. A, B, C are the borrower from the money lenders. Okay, there are three borrowers and one lender. Lender is D, whereas A, B, C are money borrowers. They together A, B, C went to D and they borrowed 1,50,000, assuming a proportion of 50,000 each. Okay, which is 50,000 for A, 50,000 for B, C is 50,000. In a natural parallels, this has to be the case because amount borrowed is 1,50,000. Right? Coming to devolution of joint liability provision, what that is saying? Section 42 says that in case the due date comes, all of them are jointly responsible for repayment of entire 1,50,000 to D because the contract between D and A, B, C, there is a contract already between A, B, C and D. So all of them approach D for a loan of 1,50,000. D has also sanctioned 1,50,000 to all the three of them. Please remember, he is not sanctioned to A alone, B alone, C alone. He has given to all the three. Therefore, devolution of joint liability provision says that all the three together are responsible for payment of 1,50,000 as an entire sum to D. Between them, they may segregate 50-50-50 or 60-40 or 50, something like that. But anyway, they are responsible together for repayment of 1,50,000 to D. So D may compel all of them to pay 1,50,000. This is the provision. D is the creditor who has given the money, so he can come back and ask A, B, C together, or all of them, any of them, to compel and pay 1,50,000. For him, he needs 1,50,000. He can come back and ask A, B, or C, or all of them, A, B, C together to repay 1,50,000. So this provision is applicable for money lending transactions. So section 42 provision deals with devolution of joint liability. This is what the provision is. Section 43. If A, B, C are saying no, I will not pay, I will not pay, there's a confusion which is happening. What happens is D can come and ask any one of them. I don't know whether you three borrow, I don't know. Either A you pay, either B you pay, either C you pay. He can compel any one of the joint promisor. JP means joint promisor. Any one of the joint promisor may be compelled to perform. So D can come back to A, ask for a entire amount of 1,50,000, or B or C. He can compel any one of them among the group to repay the 1,50,000. So this provision is section 43. Next provision is each promisor can compel contribution. For example, if D comes and puts a pressure for 1,50,000. So A can compel and B and C to give 50-50 each, and his share of 50 we can put in together and repay the amount of 1,50,000. So when D compels A can compel B and C to give 50 each, and then what is A share is another 50, he can put it and put together and give an amount of 1,50,000 to D. He can compel contribution from each one of them. Third is sharing of the loss by defaulting contribution. If, for example, if C is defaulting, he will say that he is not unable to pay. Any loss which arises due to C has to be borne by A and B because he is now unable to pay. He is refusing to pay, earlier the reason, etc. But C's share is now not possible. Therefore, A and B has to bear extra 25,000 each, 75, and then pay this 1,50,000 to D. Because for D, it has obviously 150. It doesn't matter who bears over. He doesn't know. He doesn't want it. D wants 1,50,000. So in that case, if C is not able to pay, loss arising due to C's share will be added to A and B. So they have to bear the loss on C's default between A and B, and they have to pay the amount to D. This is the sharing of the loss by defaulting contribution. Section 44. There is an exemplary provision which says that creditor D, he comes and exempts any one of them, releases one of them in the transaction. A, B and C are the joint borrowers. He comes and says, C, you move out, I am releasing you. So in that case, the remaining joint promisors are responsible for payment of the amount to D. Because due to some reason or the other, D comes and says that, C, I am releasing you from the transaction, I am exempting you from the transaction. So C is absolved from the liability. In that case, A and B alone has to pay this balance amount to D, which is obviously 150, but this 150 will be borne by A and B and will have to pay to D because there is a release of C by D. So this is the provision, effect of release of joint promisor. So let's move to the next topic, students, which is devolution of joint rights, section 45. Joint rights, what happens is where there is a duty to perform the obligation. In case A and B and C are responsible towards performance of obligation to some third party, A dies, B and C, being the parties, remaining parties, have to discharge their obligation along with A's representative. For example, A dies, B also dies, C will be there. C along with A's legal representative, B's legal representative and C, all the three will carry out their obligation. A dies, B dies and C also dies. In that case, A, B, C, all the three's legal representative together will jointly hands and they will do the performance of the obligation. Law states that wherever there is a performance obligation that is imposed on the parties are supposed to do their performance obligation. Due to the death of the parties or incapacity of the parties to perform, which reasonably be performed or capable of being performed by legal representative representative of the parties. Sorry, legal representative of the parties. In that case, the legal representative of all of them can together join hand and they can perform the obligations. This is called devolution of joint rights, section 45. Section 46 to 50 deals with the three important provisions: time and the place of performance. Generally, for a contract to be enforced, the time and the place is very, very important. When you have to deliver a car at a particular point of time, the customer will be waiting for the car. Whenever, if, for example, the car dealer and the customer goes and says the car dealer that I want item Maruti car or item Hyundai car or any specific Maruti, any kind of a car, Swift, etc. to be delivered within particular time. You have to deliver within the particular time because you agreed with the customer that this is a particular time, this is the place at which you deliver. Place may be customer house or customer's friend's house, etc. etc. But as per directions of the customer, the shopkeeper or the seller or the showroom dealer has to deliver the car to the customer. You cannot say that I cannot deliver the car at a particular point of time, or sorry sir, it has been delivered 1 day later, 2 days later. But there is no need for agreement at all, because when you agree, you have to perform. So performance of the obligation at a particular time, particular place is very important. Therefore, parties have to agree upon a particular time, particular place in order to deliver and carry out their obligation. When a contractual time and the place is agreed between parties, the performance has to happen at that place at a particular time. So it is very important. So contractually agreed time and place has to be adhered strictly or followed strictly by the parties. Otherwise, there is no need for agreeing upon time and place. Second is time for performance, where there is no time is mentioned and no obligation is to be made for time agreed. No time is agreed. What happens is within reasonable time. What is reasonable depends upon the facts and circumstances of the case. For example, if I order a car, time is not agreed. Obviously, within a day or within 6 hours, within 10 hours, the car can be delivered. From the day you actually say the car is ready, maybe performed subject to test drive, subject to road documents, subject to RTO authority signing the documents, and you can come back and give the documents. Car key ready, being ready, the automatic car key functionalities have to work, etc. Those are the lead time that is to be taken. When all the things are ready, you agree upon a time. But when there is no time agreed, you cannot say within a time. Then within reasonable time, the contractual obligation has to be performed by the parties. So no time is specified, perform within reasonable time. That is what I have underlined here. Third is where no place is specified, perform within reasonable place, which means that there is no agreed place, but you have to agree upon a reasonable place and perform. So have to be carried out. The obligation has to be performed within reasonable time. Thank you.